Hello there, I'm attorney Kelly Longtin from Kelly Longtin Law, and welcome to our YouTube channel. Today I want to talk to you about planning for real estate in a foreign country. Now, the allure of a foreign land, perhaps where the weather is milder, the pace of life is slower, and the cost of living lower. It is a dream of many Americans who want to escape our country's fast-paced, high-cost living. And that dream can become a reality and a tangible investment for Americans who purchase a home overseas. Now, wealthy individuals are leading the trend of Americans buying properties outside the United States, but they're not alone. Americans with average incomes, especially people who work remotely and retirees, are exploring overseas real estate markets in places such as Costa Rica, Panama, and Portugal in search of a better quality of life and a bigger bang for their buck. However, living abroad is very different from spending a few weeks there. In addition to the challenges of adapting to a foreign culture, prospective buyers must be aware of the financial, legal, and tax implications of buying real estate abroad before signing on the dotted line. Finding the American dream outside of America. Now, some U.S. citizens are looking abroad in search of a better lifestyle at a reduced cost. About 5.5 million Americans currently live overseas, and more may be looking to make the move in search of an American dream that is eluding them in the U.S. A 2024 Coldwell Banker report found that amid surging U.S. home costs and the rising cost of living, 40% of U.S. consumers with household income of over a million planned on buying a home overseas over the next 12 months, while two-thirds plan to purchase a home abroad in the next 5 years. Also, according to a recent Harris poll, 4 in 10 Americans have at least considered moving or plan to move abroad. The average U.S. household's monthly expenses are now up to nearly $6,500, while in a country such as Belize, it is possible to live comfortably on about $2,000 a month. Healthcare also tends to be cheaper overseas. Costa Rica, for example, provides high-quality medical care at a significantly lower cost than in the U.S. Hospital visits in Costa Rica typically cost about half as much as they do in the U.S. No matter how much they earn, Americans from different backgrounds and income levels typically want the same things: success, prosperity, good health, and upward mobility, and perhaps a bit of room to spread their wings, preferably somewhere warm. With international travel faster and more comfortable than ever, and remote work unshackling us from the office and a fixed address, Americans of all ages and economic stripes are entering the international real estate market as investors, retirees, digital nomads, and lifestyle seekers. While the romantic appeal of a new life in a different country is undeniable, the practical realities, including the legal, financial, and estate planning considerations of foreign real estate ownership, can convince even the most idealistic modern pilgrim that the move is not just a permanent vacation. Prospective buyers who are braced for culture shock may not be prepared to navigate the legal framework of their chosen destination, where issues such as mortgages, taxes, and property and inheritance laws can differ significantly from those in the U.S. For example, some countries restrict foreign ownership, impose specific registration requirements, or limit how property can be used or transferred. Let's talk about some issues that you may have to navigate as a non-resident buyer. Owning foreign real estate usually triggers tax obligations in both the U.S. and the foreign country. As a U.S. citizen, your worldwide assets, including foreign real property, are subject to U.S. estate tax. Profits from selling foreign real property are generally subject to U.S. capital gains tax, but exclusions may apply if it was your primary residence. You could also be subject to local property taxes, income taxes on rental income, and capital gains taxes in the foreign country, in addition to less-known local taxes, such as Portugal's annual wealth tax on high-value properties, Spain's deemed rental income tax even if the home is vacant, and Thailand's specific business tax on the sale of property sold within 5 years of purchase, unless the property is used as your personal residence.
When buying property abroad, you may need to file U.S. tax forms such as the FIBA, Form 5471, or Form 8858, but only if you hold the property through a foreign entity, have foreign bank accounts tied to the property, or operate it as a foreign branch. These forms may not be required if the property is owned in your name with no foreign financial accounts. To avoid double taxation, you may be able to claim a foreign tax credit on your U.S. return for taxes paid to the country where the property is located. If you eventually sell the property and pay capital gains tax abroad, this credit may help offset your U.S. tax liability. Estate plans in the U.S., including wills or trusts, may not seamlessly govern foreign real estate. Many jurisdictions reject U.S. wills if they do not meet local formalities, so meaning notarization, language requirements, or specific witnessing protocols. If a will is deemed invalid under foreign law, the property may be distributed under that country's intestacy rules, which can contradict your intended wishes. Trust pose further hurdles. Civil law countries, including Italy, Chile, and Portugal, often do not recognize the concept of a trust as it exists under U.S. law. This means that even a properly drafted U.S. trust may be ignored or deemed legally ineffective for handling real estate abroad. In Portugal, for example, long-standing ambiguity around the recognition of trust has caused complications for foreign owners relying solely on U.S. planning tools. One potential workaround is to execute an international will under the 1973 Washington Convention on International Wills. This treaty provides a standardized format for wills intended to be recognized across multiple countries. An international will must be in writing, signed by the testator in the presence of two witnesses and an authorized person such as a notary, and properly attested. The validity of an international will under this convention depends on whether the relevant countries have signed the treaty and whether their local laws allow for the intended distribution of assets. While the federal government has not ratified the treaty, many states, including California, Illinois, and New York, have enacted the Uniform International Wills Act, allowing residents in those jurisdictions to create wills intended to be internationally valid under the convention. Countries with forced heirship rules can also disrupt U.S.-based estate plans. These inheritance rules stipulate that family members, typically spouses and children, are legally entitled to inherit a predetermined portion of the deceased estate, regardless of what is stated in their will or trust. In Germany, for example, Pflichtschule, which is regarding forced share, entitles spouses, children, and in some cases parents, to 50% of what they would have received under intestate succession. Brazil, Portugal, Italy, and Mexico, depending on applicable law, enforce similar inheritance rules. If forced heirship is a concern for foreign home buyers, they may consider purchasing property in jurisdictions without forced heirship laws, such as the UK, Ireland, or certain Caribbean islands, where the legal framework aligns more closely with U.S. estate planning principles and allows for greater flexibility in directing how assets are distributed. Perusing overseas real estate listings can have your head spinning at all of the possibilities, but foreign buyers who do not know the local laws and do not work with an attorney at home and in the country where the property is located could face dizzying complications. To avoid costly mistakes that could put your investment and your legacy at risk, engage counsel from both jurisdictions who can help you with cross-border planning issues to align foreign and domestic requirements. If you're looking to plan for a property that you own in a foreign country, please contact your local estate planning attorney and have a conversation with them to see what needs to be done in order for you to align this new property with your existing estate plan. I want to thank you for watching. Please like and subscribe our page below. Hit the notification button so you'll be notified of our new videos as they are released in order to help all of you better understand estate planning, how it works, and how it can benefit your family. Till next time, I'm Attorney Kelly Longtin.